Hello, I'm Tim O'Neill. I represent over 1,000 public safety officers here in north central Illinois. Today I want to talk to you about a case I'm sure you've heard about, but maybe don't quite understand. It's called your Garrity rights. The Garrity rights emanate from a case called Garrity versus State of New Jersey. In 1967, the U.S. Supreme Court decided this case. The quick facts are there were several police officers in the state of New Jersey who were charged with conspiracy to obstruct justice. When they were brought in for questioning, they stood on their rights under the Fifth Amendment not to incriminate themselves. When they were told that if they didn't speak, they would forfeit their jobs, their seniority, and their pension, then they confessed. They were convicted and lost their jobs, their seniority, and their pension. Noting the distinct unfairness of that choice they had to make, the U.S. Supreme Court reversed the convictions and found that their confessions were not voluntary but rather coerced. Out of that case came the Garrity rule, whereupon if your employer charges you with the violation of some general order or rule of the department, they can compel you, coerce you, to make statements against your self-interest. However, those statements cannot be used against you in any criminal proceeding. And the other part of that rule is they have to advise you before you make any statement against your self-interest that it's only going to be used for internal administrative purposes and for no other purpose. That's the progeny of the Garrity rule, and anytime your employer calls you in and wants to talk to you, they should advise you of your rights under Garrity, and if they don't, the whole statement you make can be thrown out because, again, it's not voluntarily made. If you have any questions about how Garrity affects you, or if they didn't read you your rights, give me a call or send me an email. I'll be happy to answer your questions. Thanks a lot.